Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Well, unfortunately, we are at that time of the year. The Washington State Legislature is just about to go back in session, which means, of course, the bills are dropping in all the new creative ways that they're going to try to disarm you, the lawful and responsible gun-owning Washington resident. Now, you may have thought that you had enough blood let out of you last year and that maybe they were going to take it easy on you this year. No, that's not what's going to happen. We're going to talk about all the bills that have been pre-filed today briefly. We're also going to talk about a carryover bill that we're really concerned about as well. So today, let's get you all educated and let's talk about all the new ways they'll try to disarm you in 2024. Okay, Washington, so this is what we're talking about today. We are a little less than a week out from the start of the 2024 legislative session, and all the new pieces of civilian disarmament legislation are dropping. If you thought you had enough bloodletting last year, don't worry. They are not done with you yet. They have much more creative ideas on how they're going to disarm you, all under the guise that they are saving lives. I should point out that if we take a look at crime statistics in the state over the last few years, it appears that these efforts aren't working yet. I'm sure they're just a couple of more laws away from getting this fine-tuned. We're going to talk to you about 4 bills that are new, pre-filed, and we're going to talk to you about one bill that's a carryover from last year that we're really concerned. Now, anytime I start talking about this, let us all recognize that the emotional reaction that most of you are going to have is one of absolute anger. You're probably going to want to punch the computer screen. So, what I'm recommending is, before we get too far into this, do a few breathing exercises. Maybe pour yourself 3 fingers of bourbon, or of course, at least grab a barf bag. Away we go. The first bill we're going to talk about is 2054. We have already done a video on that bill. This piece of brilliant legislation sponsored by Representatives Farvar and Ormsby out of North Seattle and Spokane. Yeah, this is going to save a lot of lives, because what this basically does is this restricts all FFLs in the state of Washington from selling a person any more than 1 firearm per 30-day period. So you would only be allowed to purchase 1 gun every 30-day period. Now, there are some exceptions that are written into the statute, but unless you're law enforcement, military, National Guard, a few other things, yeah, none of those exceptions are going to apply to you. Of course, there's probably an exception for if you got a concealed carry license, a CPL, obviously, you've been thoroughly vetted. No, that's not there as well. So that is House Bill 2054. It is sponsored again by Farvar and Ormsby out of North Seattle and Spokane. Again, this would limit your purchase to 1 firearm for every 30-day period. The next bill is House Bill 1902, of course, sponsored by your favorite gun grabber, Liz Berry. Now, Liz, I doubt you're watching this channel, but if you are, listen, you are an absolutely atrocious legislator, because you haven't written a piece of gun control legislation yet. No, you have all your cronies for every town in Giffords do it, or what you've done in a lot of instances, you just cut and paste from California. Now, some of you may recall House Bill 1143. It would have required a pre-purchasing licensing requirement that required all sorts of training, including live fire training. Now, shockingly, last year's legislature thought that might be a little too much for an inalienable right. So a lot of that was pulled out. And the watered-down version that was passed was House Bill 1143, which now requires a pre-purchase educational safety class. Free one, linked up down below with the compliments of the folks at Sporting Systems. What 1902 does here is it just takes everything that got pulled out of 1143 from last year and puts it right back in. So if passed into legislation, this is going to require a new license. You will need to get a license to purchase a gun. Let me say that again. You will need to get government's permission before you get to exercise an inalienable right. I will also point out to Representative Berry that this exact legislation was ruled unconstitutional both in Maryland and Oregon just last month. I know that's not going to stop you from doing it. But here's the other thing, and this is what's happened in a lot of places. California, Hawaii are 2 examples. When you create this pre-purchasing licensing requirement that requires live fire training, and you say, well, and then the state patrol will be tasked with setting up what that approved training is. Shockingly, once the law is implemented, that training is never in place. And so, like right now, there is nobody in the state of Hawaii who can procure a license to purchase a firearm because they don't have any approved training, even though the law has gone into effect. So that is an incredibly dangerous bill. That is 1902. You know it's dangerous. It's sponsored by Liz Berry. Let's talk about 1903. This is another piece of Liz Berry legislation, which is, again, never a good thing. Now, I'm not really sure what's going on here. 1903 would create an obligation on all gun owners that if your firearm is lost or stolen, you must report it within 24 hours of learning that it was lost or stolen. Now, interestingly enough, if you already take a look at pre-existing 941-360, our safe storage provision, it says that you have 5 days to report a lost or stolen firearm upon learning of its disappearance to avoid any type of criminal liability. Now, Representative Berry didn't jive any of this up with 941-360, but this is my concern here, is that the legislation would require that you have to report the firearm as lost or stolen within 24 hours, but then you also would need to report the make, the model, the serial number, and any other kind of identifying marks. Now, I have a lot of firearms, and I can probably tell you the make and model of just about all of them. The serial number, I don't know, damn serial number. And the interesting thing is if you purchase any of these as a Washington State resident, the Department of Licensing already has a record of it. How do I know that? Because prosecutors hand me that record every time when they're asking for firearms to be forfeited by my clients. So yeah, there already is a gun registry. They already know. Are you saying then that if a person reports the firearm is stolen and can tell you the make and the model and that's all, they're still guilty of this offense? Now, this offense, if enacted in the law, would be a $1,000 civil infraction. It's not a criminal offense yet, but it would be a $1,000 civil infraction. That is House Bill 1903. Okay, the newest one to drop today, and this is absolutely the most dystopian piece of legislation you'll ever see, and was the subject of this video right here, because shockingly, this exact law is under constitutional challenge in California. I'm talking about California Penal Code 26806. This is House Bill 2118, sponsored by, shockingly, Representatives Whalen and Berry. Oh my God, who would have ever thought? Now, 2118, this exact law is subject to the lawsuit of Richards v. Newsom. And if you want to learn more about it, here, we'll go ahead and link that video right there up below so you can understand. Now, hear me out here. This is a complete George Orwellian piece of legislation, because what this does is it will then mandate to FFLs how their physical structure of their buildings need to be, and it will mandate a certain type of high quality 24-hour permanent surveillance of specified areas within the FFL. Now, as you know, probably a lot of FFLs have a lot of this in place, and you say, okay, so what's the big deal? Hey, what about home-based FFLs? You see, because that's one of the challenges right now going on in California. If you have a home-based FFL, the state of California expects to be able to put 24-hour government surveillance into your home. This does not limit this to retail operation FFLs. This is any FFL, and there are a lot of home-based FFLs. There is a cost included in this, an astronomical cost when you consider the types of security measures that would be required here. Again, some gun stores probably have all of them or most of them in place. A lot of them, this could be the type of capital investment in the company that they simply can't do, and this will absolutely kill many FFLs. The other thing is, and this is the chilling effect that is being argued about the California Penal Code, is that all FFL stores will have the sign that's posted, "These premises are under video and audio surveillance. Your image and conversation may be recorded." Now, the chilling effect is that if you don't really know what's going on, you will think that the FFL is doing this on their own prerogative. The sign should say, "Warning, these premises are being ordered to be under surveillance by video and audio by order of the state of Washington." That would be an accurate statement. So you could understand the chilling effect it has on people's willingness to actually walk into that place of business. And then the final piece of legislation you need to be aware of, we have talked about this one before, and I will tell you folks, every time I talk about state preemption, my videos do not get good traction. And I think a lot of you don't think it's a big deal. But if you think it sucks right now to have the Washington State Legislature write your gun laws, wait until the city of Seattle, King County, city of Tacoma, city of Bellevue, and any of those jurisdictions get to do it. Because what 1178 does is it basically eradicates 941-290, the state preemption law. It allows counties, cities, municipalities, everybody to write their own gun laws. You will see 3-round limitations in Seattle. You will see 5-round limitations in Berrien. You will see 1-round limitations in Bellevue. I mean, it's going to be crazy. The concealed carry laws will change, and you will end up with this tapestry of gun laws where if you're traveling across state, you're going to go from legal to illegal to legal to illegal. One of the things that laws need to do is they need to have a uniform application, and it needs to put every citizen on notice. This is a statute that actually eradicates both of those. So that again is House Bill 1178 that was sponsored last year by Representatives Hackney, Levitt, Reed, and of course, Barry, as well as others. Okay, so like I say, we got 4 pieces of new legislation, we got 1 carryover, and we got plenty of days left for new legislation to be introduced. We will obviously keep you posted about everything that's happening, and if there are action items that we need, we will be sure to let you know. If you want a more up-to-date account of what's going on in Olympia, I highly recommend that you sign up for the Conservative Ladies of Washington's Legislative Action Center. We're going to go ahead and link that up in the description box below. They do a fantastic job of keeping you literally up to date, minute by minute, what's going on in Olympia, and making it easy for you to get involved and try to stop some of this insanity. Listen, if you got any questions about these bills or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is also down there in the description box. Now, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.